Welcome to the third and final video for topic 8, the Privity Rule, and we're going to talk here about circumventing the Privity Rule. So, what are the circumstances in which the Privity Rule can be circumvented or avoided or gotten around? Essentially, the four main categories are set up on the slide in front of you. The promisee can hold rights under the contract on trust for a beneficiary or a third party who has rights under the contract. The beneficiary, that third party, can be entitled to assert an estoppel against the promisor. The beneficiary can be entitled to claim damages for misleading or deceptive conduct, so outside of the contract regime altogether. And again, outside of the contract regime, a beneficiary can be entitled to a claim of damages in tort. So, working through, in order to circumvent the rule, we need to actually apply an exception. And I think you've worked out by now that in order to learn a legal concept, you really need to understand the exceptions to it first. And basically, I've got 7 different examples of exceptions on the screen. The Cools and Bagot exception, okay, we're working with over to there, but, with over to there, what am I saying? With a minority decision, but the joint promisees exception. Exemption clauses where there's intended to be a benefit for an agent or an employee. Some statutory provisions, like the Australian Consumer Law, etc. Situations involving a trust, situations involving agency, 3-party collateral contracts, and assignment. So let's go through each of those one by one. Where I got myself a little muddled when I was talking before is I want to refer you back to Cools and Bagot, in particular in this case to Justice Windier's dissenting opinion. Essentially, he's saying that the promise is not merely made to a promisee for the benefit of a third party, but is made to the promisee and the intended beneficiary together. There is no third party to the contract. Instead, there is a promisor and some joint promisees. Now, whilst this is a dissenting opinion, and in the end, Mrs. Cools was not successful because of the application of the Privity Rule. The statement that Justice Windier makes about joint promisees, had the facts, as found by the majority, supported her being found to be a joint promisee, are not in dispute. This was also the view of Chief Justice Barwick, also dissenting. 2 of the majority judges, Justice Taylor and Justice Owen, expressly agreed with this view. So even though it comes from a minority and dissenting judgment, in relation to the subject matter of this particular paragraph, it does represent the opinion of the majority. And here is a speech bubble summarising much more eloquently what I was just saying. The next example I want to talk about, a case that's not in your casebook, Wilson and Darling Island, Stephen Doring and Lightridge Company, 1956 decision of the High Court. In that case, goods were being shipped to the plaintiff in Sydney, and they were damaged through the negligence of the defendants, a stevedoring company. Now, many of you may not be aware of what stevedores do. Stevedores basically operate ports. So when you think about the carriage of goods by sea, essentially they get put on a ship, they get taken to a port, and they get taken off the port. And they need to transfer or get delivered, depending on how the contract works, either to the ultimate consumer of those goods or owner of those goods, to some other distribution process, somebody else in the chain. Now, it would be absolute chaos, if people just went to the port to pick up their stuff directly from the ships. And ports are notoriously really difficult and high injury-prone workplaces. So for very, very many years, there's been this profession of stevedores who basically work on the ports to transfer goods from ships safely to their next port of destination. And so basically what's happened here is goods have arrived on the ship by the carrier. The stevedore has taken them off the ship but caused the damage. So there was a bill of lading, again some specialist language here in relation to transport or courier contracts, but a bill of lading is just really another piece of terminology to mean contract. And so there was a contract between the shipper and the carrier, and it had an exclusion clause that said that the carrier had no responsibility for the goods. But the clause didn't say anything about third parties. So the stevedore was trying to get the benefit of that contract because the plaintiff sued the stevedore. They knew they had no cause of action against the carrier, so they sued the stevedore directly. And the stevedore claimed to be the carrier's agent and that they should be protected by the clause. And then they held that, the court held that the clause protected the carrier but didn't protect the stevedore. The stevedoring company can't take the benefit of a contract term to which it's not a party. Now you're asked to compare that to the case of Scrutton's and Midland Silicons. That's a UK case and it came to the same conclusion. In both cases the stevedores were unsuccessful. But in that case, Lord Reed talked about 4 particular things that needed to happen in order for the stevedore to be successful. So firstly, the contract needs to make it clear that the clause was intended to benefit the third party. So it needed to say that the exemption protected not only the carrier, but its agents and subcontractors as well. The principal, so in this case the carrier, needs to have been contracting on their own behalf and as agent for the stevedores. Thirdly, the principal needed to have authority to contract on the third party's behalf, or the third party must have ratified the contract in some way. And fourthly, the third party, so the stevedore, must have provided consideration for the exemption from liability. And this idea, or these provisions, have been approved by the High Court in the case of Port Jackson stevedoring and Salmon and Spraggan. This is the case that's in your casebook at 11.35, and those are the key points that you need to be able to extract from that case. So moving on, what are the statutory exemptions? The rule against privity has been modified by statute in several jurisdictions in relation to particular circumstances. In particular, the Australian consumer law gives a purchaser the right to require wholesalers or manufacturers to perform statutory guarantees. And we'll talk about those when we talk about terms that are implied by law, I think in topic 11 actually. Also, insurance legislation requires third-party beneficiaries to be named in some states, but insurance legislation provides for insurers to step in and receive the benefit of contracts in certain circumstances. Nextly, where did I come up with that? Next, I want to talk about three-party collateral contracts. Now, these are a little bit tricky to understand, so be patient, stop and think about it if you need to, come back to this. Essentially, we're talking about a situation where A promises something to B, as a result of which B causes C to contract with A, or to provide some benefit to A. B isn't a party to the contract, but B has made a promise that has caused the contract to happen. If A breaches the contract and B loses the benefit that A promised, then B may be able to sue A. Okay, confusing, right? Let's actually use an example. This one isn't in your text or your casebook, so bear with me while I talk to you about the facts. Basically, Shanklin Pier owned a pier. Not surprising given their name. And a company called Detel Paints basically went to them and said, we've got this fantastic paint, it's going to last forever, it's absolutely perfect for your pier, we think that you should use it and it'll last 7 to 10 years. So Shanklin said, great, and they went out to tender, and they specified in the tender to people who were making bids to get the job of painting the pier that they had to use the Detel paint. So lovely little painting company came along. They were the successful tenderers. They did a fantastic job. Only the paint that they used, which was the Detel product, didn't work. It wasn't suitable. So Shanklin couldn't sue under the contract that it wasn't a party to. So it couldn't sue under the contract for the purchase of the paint, because the paint was purchased by the painting company and Shanklin wasn't a party to that. But it could sue for a breach of what was called the collateral agreement, under which it had instructed a contractor to buy that paint in preference to something else. So this is quite a complex idea, and it's kind of a legal logic in a sense, that it's saying that other than for Shanklin's requirement that let me put that around the other way. Other than for Detel's promise to Shanklin that the paint would last for 7 to 10 years, Detel wouldn't have got the contract with the painting company. As a consequence, if that promise that it would last 7 to 10 years is breached, then Shanklin has a right under the collateral contract to sue Shanklin, because it had instructed the contractors to buy that paint in reliance on that promise. So when can a party who's not directly involved in creating a contract be a party to it? Two situations, one of which we've already discussed in relation to the stevedoring case, agency, and the other is an assignment or a novation. So an agency is where one of the parties acts or is involved in some way as the agent for the non-involved party. And an assignment or a novation is when there is a transfer of some kind, a transfer of business or some other sale that results in the contract being transferred from one set of parties to another. So let's start with agency. So in this regard, you should look at your textbook at 11.35 and your casebook at 11.32. The privity rule doesn't apply if a person promised to benefit under a contract can show that one of the parties involved in the contractual negotiations entered into the contract as their agent. So an agent is a person who has the power to enter into a contract on behalf of someone else. Someone else is commonly referred to as the principal. If an agent acting as the agent of a principal makes a contract with, let's call them party B, the other contracting party, then the person on whose behalf the contract has been made is a party to the contract, even though they weren't directly involved in contractual negotiation. So to show that an agency relationship exists, it's necessary to prove that the principal expressly or impliedly consented to it. The best example that we see of this is in the ordinary act of buying and selling real estate in an Australian market. What happens is that the vendor appoints an agent to negotiate on their behalf. So ultimately it's very rare for the agent to actually sign the contracts on their behalf, but if that was the scope of their instructions, that would in fact be possible. And you will see this too with, say, family members who are negotiating or acting for another family member who is unwell or overseas or away. So to show that an agency relationship exists, you need to demonstrate that the principal expressly or impliedly consented to the agent acting on their behalf. Again, the case here that I want you to look at is the Port Jackson stevedoring and Salmon and Spraggan case, which I mentioned earlier. And you'll see from that case that where a contract makes it clear that a benefit is to be conferred on a beneficiary, the contract makes it clear that the promisee is acting as an agent for the beneficiary, The promisee was authorised to enter into the contract on the beneficiary's behalf, or the contract was subsequently ratified, and the beneficiary provided consideration for the promise, then the beneficiary is a party, and therefore there's no privity issue, and therefore the beneficiary or the person who is in fact the contracting party can enforce that contract. So what about assignment or novation? In some instances, contractual parties can transfer the contractual rights or obligations to third parties. This is commonly referred to as an assignment of contractual rights. Where contractual rights that are owed by one party, let's call them the assignor, are transferred to a third party, the assignee is the only party able to enforce the contract. Only non-personal contractual rights can be assigned, so the identity of the assignor is not material to the contractual relationship or the contractual performance required. Those kind of obligations can be assigned. In all other cases, so where the identity of the person performing the contractual obligation is relevant or necessary, then basically what we need is an assumption or a novation. So a novation is a type of equitable deed which provides for the assumption of obligations. So the process of novation relates to the transfer of contractual obligations from one of the contracting parties to a third party. The effect of a novation is that the original contract is terminated and a new contract is formed between one of the original parties and a substituted or a new party. For a novation to occur, it's generally necessary to show that consensus has been reached between all the parties. So in other words, the person who has the ongoing obligation or the ongoing right under the contract that is being novated by the other party needs to agree to the change. And this can be really important in a sale of business, for example. And we'll do an exercise in class to think through what the issues are in relation to this. And for those of you who are participating online, I'll make sure that the quiz questions and resources help you think about when an assignment or a novation might be necessary. So lastly, what other ways are there to circumvent the privity rule? There are a number of different ways. Take a look at your casebook in relation to the ones that I've listed here. We just can't go into all of them in any detail, but I'm happy to address any questions that you might have in relation to any of these areas. Remembering too that whilst we're looking here at contract law, there might be other sources of law, in particular the operation of tort or equitable principles that might be used to circumvent privity from time to time. Thanks for your attention. As always, any questions, concerns, frustrations, even compliments, send me an email, get involved in the discussion board, or come to class and have it out with me there. Look forward to that. Cheers.